Imagine this. You inherit a rifle from your grandfather. You already own 3 firearms of your own. You decide to sell 2 of them, guns you bought legally, guns you paid for with your own money, guns that belong to you. You post an ad online. You find a buyer. You complete the sale. And then, months later, federal agents show up at your door. Not because you did something wrong, not because the buyer had a criminal record, not because anyone got hurt, but because the ATF decided, on their own, without Congress, that selling your personal firearms made you an unlicensed gun dealer, a federal felony, up to 5 years in federal prison, up to $250,000 in fines, for selling guns that belong to you. 100 million American gun owners were living under that threat. Most of them never knew it, and the mainstream media never told them. Today, that changes. Because a federal appeals court just issued a ruling that every single gun owner in all 50 states needs to understand right now. To understand why this ruling matters so much, you need to understand what the ATF actually tried to do, and how far they were willing to go to do it without asking Congress for permission. For decades, private firearm sales between law-abiding Americans were legal under federal law. If you owned a gun and wanted to sell it, you could sell it. No federal dealer license required. No mandatory federal background check. No mountains of federal paperwork. Congress wrote it that way deliberately. They understood that Americans have a constitutional right to keep and bear arms, and that right includes the ability to transfer property you legally own to another law-abiding adult. That was the law, written by elected representatives, passed through the legislative process, signed into existence the way laws are supposed to be created. Then the ATF decided they didn't like it. In early 2025, the Bureau of Alcohol, Tobacco, Firearms, and Explosives quietly introduced what they called the Firearms Transfer Integrity Rule. Sounds official. Sounds boring. Sounds like something you'd scroll past without reading. That was the point. Because buried inside that rule was one of the most aggressive expansions of federal authority over private gun ownership in modern American history. Under the ATF's new interpretation, any private firearm sale could now be treated as you being engaged in the business of dealing firearms, which requires a federal dealer license. How did they define engaged in the business? Here is where it gets outrageous. They said that a profit motive could be established by something as simple as selling a gun to fund the purchase of another gun, or by posting an online listing for a firearm you own. No minimum number of sales, no threshold of transactions, 1 gun, 1 sale, 1 listing. That was enough. Under their rule, if you sold a single pistol from your personal collection and used the money to buy a different firearm, the ATF claimed the authority to treat you as an unlicensed firearms dealer. And an unlicensed firearms dealer operating without a federal license is committing a federal felony. They even tried to argue that firearms you originally purchased for personal protection no longer qualified as personal property once you decided to sell them. That pistol you bought last year for home defense? According to the ATF's interpretation, the moment you decided to sell it, it became inventory. You became a dealer, without a license, a criminal. Let that sink in for a moment. I'm Rebecca Turner. This is AmeriBrief, where we translate federal legal decisions into plain language that every American can understand and use. If you are a gun owner, if you have ever sold a firearm from your personal collection, if you have ever traded a rifle at a gun show or passed a shotgun down to a family member, subscribe to AmeriBrief right now and turn on that notification bell, because this legal landscape is moving fast. And the next ruling could affect what you legally own before you even hear about it. In the next 15 minutes, I am going to show you exactly what the ATF tried to do, exactly how a federal court stopped them, and exactly what 3 things every gun owner needs to do right now to stay protected. Stay with me, because what comes next is the part that most channels will get completely wrong. The ATF's rule did not go unchallenged. 3 major gun rights organizations decided they were not going to let this stand. The Second Amendment Foundation, Gun Owners of America, the National Shooting Sports Foundation, along with individual gun owners from Texas, Florida, and Arizona. They filed a federal lawsuit challenging the entire rule. The case moved quickly, and on March 28, 2026, the United States Court of Appeals for the Fifth Circuit delivered a ruling that the ATF did not see coming at the scale it arrived. 78 pages. The court did not mince words. The majority opinion stated clearly that the ATF's Firearms Transfer Integrity Rule was unlawful, that it exceeded the statutory authority granted to the agency by Congress, that it directly violated the plain text of the Gun Control Act as written and amended by elected representatives. The judges called the rule arbitrary, capricious, and an unconstitutional abuse of agency power. But here's what made this ruling different from every other Second Amendment court victory of the past decade. The court did not just strike down parts of the rule. They did not send it back to the ATF for revision. They did not limit the decision to Texas or to the states within the Fifth Circuit's jurisdiction. They issued a permanent nationwide injunction. Let me be very precise about what that means. A permanent nationwide injunction means the rule is dead everywhere, not just in Texas, not just in the South, not just in red states, in all 50 states, effective immediately, with no exceptions. The ATF is permanently blocked from enforcing this rule anywhere in the country. They cannot investigate you under it. They cannot prosecute you under it. They cannot use it as the basis for any legal action against any gun owner anywhere in America. The court also delivered something that goes far beyond this single case. They reinforced a fundamental constitutional principle that should never have needed reinforcing, but clearly did. Congress writes the law. Agencies enforce the law. Agencies do not get to rewrite the law because they disagree with the way Congress wrote it. The ATF had been operating as if they had the authority to define what the law meant, not just enforce what it said. The Fifth Circuit looked at that arrangement and said, clearly and on the record, no. This ruling does not exist in isolation. The consequences of what the Fifth Circuit just did are going to ripple through the federal legal system in ways that will play out for years. Here is what is already in motion. First, state legislatures are watching. Some states that have been quietly building their own frameworks to restrict private gun transfers now face a more complicated legal environment. Any state law that attempts to achieve what the ATF's federal rule was trying to accomplish will face immediate legal challenges under the same constitutional principles this court just affirmed. States that try to reimpose these restrictions through different language will find those laws challenged in federal court, and the Fifth Circuit's reasoning will be cited against them. Second, other federal circuits are taking notice. When the Fifth Circuit issues a ruling this significant, it creates legal momentum. Cases challenging similar agency overreach that have been stalled in other circuits for years suddenly have a powerful precedent to build on. Attorneys who have been waiting for exactly this kind of ruling are already filing. Third, the ATF itself faces operational disruption. The ATF built compliance systems, enforcement protocols, and training programs around the assumption that this rule would stand. All of it now needs to be dismantled and rebuilt. That is not a small administrative adjustment. That is a fundamental restructuring of how the agency operates in one of its most active enforcement areas. Fourth, this opens the door to bigger challenges. Every time a major federal firearms regulation falls in court, it creates legal momentum for adjacent cases. There are currently active lawsuits challenging provisions of the National Firearms Act that have been on the books for nearly a century. Restrictions on short-barreled rifles, suppressors, and other heavily regulated categories of firearms. This ruling strengthens those challenges. The ATF will appeal, that is almost certain. If this case reaches the Supreme Court, the outcome is not guaranteed. But here is what you need to understand right now. While any appeal is pending, this injunction stands. The rule is blocked today. It is blocked tomorrow. It is blocked until a higher court says otherwise. And we are not at the end of this fight. We are at the beginning of a new chapter. And you need to be ready for what comes next. Let me bring this down to your life specifically, because this is where most coverage completely falls apart. They explain the ruling in legal terms and leave you with no idea what actually changes in your day-to-day life as a gun owner. Scenario 1. You own a modest personal collection, maybe 6 or 8 firearms accumulated over the years. You decide to sell 2 rifles you no longer use and trade a pistol with a friend at your local range. Under the ATF's now-dead rule, those 3 transactions could have been used to argue that you were engaged in the business of dealing firearms without a federal license, a felony. As of right now, that threat is gone. You have the legal right to sell firearms from your personal collection without the federal government treating you as an unlicensed dealer. The protection Congress always intended you to have has been restored by this court. Scenario 2. You are a woman living alone. You purchased a handgun 2 years ago for home defense. You have since upgraded to a different model and want to sell the original to a trusted friend. Under the ATF's interpretation, that firearm, purchased specifically for self-defense, could have been reclassified as inventory the moment you decided to sell it, making you a dealer without a license, a criminal. That interpretation is now permanently blocked. Your self-defense firearm remains your personal property. Your right to sell it to another law-abiding adult is federally protected. Scenario 3. You are a small business owner who also holds a federal firearms license. This ruling matters to you too, but for a different reason. The ATF's zero-tolerance policy for licensed dealers was separately challenged in court and significantly weakened. Under the old policy, a single clerical error on one form out of thousands of clean transactions could result in permanent license revocation. One mistyped digit, one missed initial, one administrative mistake in a business that had operated without incident for years. That threat has been substantially reduced, which means more licensed dealers stay in business, more competition in the market, better prices for you. More options in every state. Before we go any further, I want to hear from you directly. Did you know that the ATF's rule could have applied to a single private sale from your personal collection? Drop your answer in the comments right now, yes or no. I read every single comment. Scenario 4. You travel between states regularly with your firearms. Here is the critical warning for this scenario, because this ruling changes one part of your legal situation, but not everything. The Fifth Circuit's ruling blocks the federal ATF rule. It does not eliminate state-level transfer requirements. Some states maintain their own private transfer laws that operate independently of federal law. Before you complete any private sale or transfer, you must check the current laws in your specific state. Not the state you were in last year, the state you are in right now. Those state laws still apply, and violating them still carries serious consequences. There is a significant amount of misinformation spreading right now about what this ruling actually does. Let me correct the most dangerous ones before they cause real problems for real gun owners. Myth number 1. People are saying this ruling means you can now sell firearms anywhere, to anyone, with zero restrictions. That is completely false. This ruling strikes down one specific ATF rule, The Firearms Transfer Integrity Rule. It does not eliminate federal background check requirements for licensed dealer sales. It does not change who is legally prohibited from owning a firearm. It does not remove state-level transfer requirements. It does not affect regulations on fully automatic weapons, suppressors, or short-barreled rifles under the National Firearms Act. Know what changed. Know what did not. Myth number 2. Some people are claiming this ruling has already been appealed and overturned by a higher court. As of the date of this video, that is false. The permanent nationwide injunction is in effect. Appeals have been filed. That is accurate. But the ruling itself has not been suspended, stayed, or reversed. Follow AmeriBrief. If anything changes on this story, you will hear it here before the mainstream media has a chance to spin it. Myth number 3. You may be hearing that your existing firearms license, if you hold one, is now invalid or unnecessary because of this ruling. That is wrong and potentially dangerous advice. If you hold a federal firearms license, your license still applies. Your reporting requirements still apply. Your record-keeping obligations still apply. This ruling affects private transfers between non-dealers. It does not change the obligations of licensed dealers. Do not make any decisions about your license based on social media posts or secondhand information. Myth number 4. People are saying the ATF is completely finished and cannot touch gun owners anymore. That significantly overstates what happened here. The ATF lost this specific case involving this specific rule. The agency still exists. It still has statutory authority in numerous areas. It will adapt. It will find new approaches within the boundaries the court has now drawn. A victory like this demands vigilance, not complacency. Complacency is exactly how rights erode slowly over time, without anyone noticing until it is too late. These victories are not random, they are not coincidental, and they are not the work of luck. They are the direct result of a single Supreme Court decision that fundamentally changed how every federal court in America is required to evaluate gun regulations. The 2022 Supreme Court decision in New York State Rifle and Pistol Association versus Bruen established a new constitutional standard. It told every lower federal court in the country that firearms regulations must be consistent with the historical tradition of firearm regulation in the United States at the time the Constitution was written. If a modern restriction has no clear historical parallel from the founding era, it is presumptively unconstitutional. Courts are now applying that standard rigorously, and agency after agency is losing. The ATF's transfer integrity rule had no historical parallel. The pistol brace reclassification had no historical parallel. The zero-tolerance license revocation policy had no historical justification. All three have now been struck down or severely curtailed. For the first time in decades, the Second Amendment is being treated as a real constitutional right, not a bureaucratic inconvenience to be managed through regulatory creativity. That is the larger story here. And it is a story that the mainstream media is deliberately not telling you. Here are the 3 things I need you to walk away knowing after this video ends. Number 1. The fundamental shift in this ruling is about who holds the authority to define the law. For years, the ATF operated as if Congress's words were merely a starting point that the agency could interpret however it wanted. The Fifth Circuit has now drawn a line in permanent ink. Congress writes the law, the ATF enforces it. The ATF does not get to rewrite the law to expand its own power over 100 million American gun owners. That principle has now been affirmed at the federal appellate level with a nationwide injunction behind it. Number 2. Even if this specific ruling is modified on appeal, the direction of legal movement is established, and it is not reversing. The Bruen standard is in place. Courts are applying it. Multiple ATF regulations have already fallen under it. The constitutional framework for Second Amendment rights is stronger today than it has been in 50 years. That is not temporary. That is a structural shift in how American law treats your right to keep and bear arms. Number 3. A court victory does not protect you if you do not know it happened. The law just changed in a way that directly affects what you can legally do with firearms you own. But state laws still vary. New federal approaches are already being developed, and the legal landscape will continue to shift faster than most people realize. The gun owners who stay informed are the gun owners who stay protected. The ones who don't are the ones who end up in situations they never saw coming. The founders did not write the Second Amendment as a privilege the government could revoke when it found the paperwork inconvenient. They wrote it as a right, an individual right, a constitutional right, a right that belongs to you, not because the government granted it to you, but because you are an American citizen and the Constitution says so. The ATF spent years trying to chip away at that right, through regulatory creativity, redefining words Congress had already defined, expanding their own authority far beyond what any elected representative approved. The Fifth Circuit just told them, clearly and permanently, that it stops here. That is a significant moment. Not just for gun owners, for every American who believes that the Constitution means what it says, and that unelected bureaucrats do not get to rewrite it from inside an agency office. The mainstream media will not give this story the coverage it deserves. That is why AmeriBrief exists. That is why you are here. And that is why we have to keep building this together. The people watching right now are the ones who will be ready when the next fight comes. And it is coming. Stay informed, stay protected, stay free. I'm Rebecca Turner. This is AmeriBrief. Subscribe to AmeriBrief right now and ring that notification bell, because this legal situation is moving fast, and the next ruling could affect what you legally own before the mainstream media even notices it happened. Drop a comment below and tell me, did you know this ATF rule existed before watching this video? I want to know how many gun owners were living under this threat without realizing it. And share this video with someone you know who owns firearms and has ever sold, traded, or transferred a gun from their personal collection, because what they just learned in this video could protect them from a federal felony charge they never saw coming.